2024. Welcome everyone to Washington Arbitration Week. This is our fifth annual conference, and we'll be going on all this week until Friday. And we had a fantastic and enthusiastic response from the law firms and practitioners here in Washington. But as we have over the whole history of Washington Arbitration Week, we've always made efforts to make our sessions virtual and available to the general public and to the world. And as a result, we have folks watching from every corner of the world and supporting and taking part in the conference. So we have many of these conferences put on by various cities, but we like to think that not only are we showing the best of Washington and our arbitration community, but we are showing this to the world as well and sharing what we have to offer. So thank you to everyone who's dialed in virtually, and thank you to the folks here today. We're going to start off with a really fantastic session. It has a very long title, but the short title is, if not investor state arbitration, then what? So the then what is going to be, I guess, a big part of the discussion here today. And of course, this is a very topical issue in the international arbitration community. The reforms have been attempted and are ongoing in ISDS, and there is a certain level of critique that has existed over the whole life of ISDS, which the community and the states who govern these treaties are grappling with. And I'm looking forward to hearing from our panel today. We're being moderated by a very able moderator. This is Josh Shiff on my right. He's a partner here at Wiley Ryan. Josh has extensive experience in litigation and international arbitration, involving a broad range of industries, including energy, natural resources, cryptocurrency, and financial services. He also advises companies on national security law, public international law, and transnational litigation in U.S. courts. Josh teaches international arbitration as an adjunct professor at the University of Virginia School of Law and is a fellow of the Chartered Institute of Arbitrators and a FINRA arbitrator. Before joining Wiley, Josh was in the Office of a Legal Advisor at the U.S. Department of State. So Josh has great experience in this area, and I know will moderate a fantastic panel. So on that note, I'll just pass it over to Josh and take it away. Thanks very much, Josh.
Thanks so much, Ian, and welcome everyone. It's good to see you all this morning. It is my distinct pleasure to introduce you to today's panel to start off Washington Arbitration Week, and I think our panel is a perfect way to start the week because it really is at the intersection of law, policy, and the global economic order. I'm going to read the full title because it's a delightful mouthful. It is, if not investor state treaty arbitration, then what? Can investment contracts replace investment treaties, including bilateral investment treaties and free trade agreements with investment chapters? That is perhaps a lot to start the week, but you are in good hands because we have a very able and expert panel to discuss this. I will introduce them and then give a very brief introduction of this topic, and then we will proceed with a number of different angles in which investment contracts and investment treaties might overlap. So first, introductions for our panel. I have to my left Jim Mendenhall, who is a partner in the International Arbitration and Trade Group of Sidley Austin in Washington, D.C. He has handled some of the largest and highest profile arbitration cases over the last 10 years. Prior to joining Sidley Austin, Jim was the general counsel of the Office of the U.S. Trade Representative and the Assistant USTR for Services, Investment, and Intellectual Property. He led the USTR legal team in connection with the development of the 2004 U.S. Model BIT and the investment chapters of multiple U.S. free trade agreements. At the end of the table, I have Uche Unwamebu, who is an international attorney at Aaron Fox in Washington, D.C. His current practice focuses on international investment arbitration, commercial disputes, and advisory services. For more than a decade, Uche was senior counsel at the World Bank's International Center for Settlement of Investment Disputes, or ICSID, in Washington, D.C. He was involved as secretary or team leader in over 70 cases in various economic sectors, and was a core member of the 2016 ICSID Rules Amendment team. We also have Jonathan Aldridge, who is of counsel in the international arbitration practice of the global law firm Paul Hastings, based in Washington, D.C. Jonathan has nearly 2 decades of experience advising multinational corporations, international organizations, and sovereigns in high-stakes cross-border disputes. He works with clients from a wide range of industries, and his international practice spans investment treaty arbitration, commercial arbitration, and U.S. trial and appellate litigation. And last but not least, we have Michael Rodriguez Martinez, who is an associate at Hughes, Hubbard & Reed. He is a member of the firm's arbitration practice group, and he has spent almost 10 years handling disputes in the international sphere. Michael also clerked at the United States Court of Appeals for the 11th Circuit. And outside of private practice, Michael is a professor at Georgetown University Law Center teaching advocacy in international arbitration. So you've heard a lot about investment arbitration and commercial arbitration and contracts, cross-border disputes among the experience of this group of panelists. So those are the issues we're going to unpack. But just to give a very quick introduction before we start moving through this, we're talking about 2 different types of legal instruments today. First is an investment contract. That's a contract between an investor and a state. It's a direct contract that the parties can negotiate. They can include specific provisions to govern the investment, including dispute resolution. The second type of legal instrument is an investment treaty. That is an agreement between 2 states. No investor is a party to that agreement, and it provides consent. Many investment treaties provide consent for arbitration of disputes and provide a framework governing the investment that protects against expropriation or discriminatory treatment and the like. And so, as you will hear more about, and as many of you probably know, the system of investment arbitration has been under scrutiny in recent years. Critics argue sometimes that these treaties favor investors at the expense of state regulatory autonomy, and that alternative frameworks should be explored. So that brings us to our topic. Can investment contracts be a substitute to investment treaties? We're going to approach this from 4 different questions. The first is, can the contracts accomplish the same objectives as investment treaties? Second, at a more technical legal level, how are these contracts different from treaties, such as with respect to the forum for dispute resolution and the applicable law? Third, what happens when investment contracts and investment treaties overlap in their coverage? And fourth, what are other options for addressing investor-state disputes? So we're going to tackle those questions one by one. We will have each panelist give an overview of the issue, followed by some discussion among the panel. We welcome questions during that time or at the end, so please write down notes, send in your questions, and we look forward to a robust discussion. To kick things off, we are going to start with Jim Mendenhall, who will tell us more about the context of this investment contracts versus investment treaties issue. Over to you, Jim.
Thank you. So I think my job is sort of table setting here to set the context, as Josh said. And I'll start off with the story that most of you are already familiar with, which is what's been happening in the area of investor-state dispute settlement over the last 20 years, and what has brought us to this point where we're thinking about significant reforms. Really starting 20 years ago with the introduction of the NAFTA, ISDS became very controversial. The controversy has not died down in the ensuing decades. If anything, it's gotten more intense. You've had a confluence of events that has led to that outcome. You had NAFTA itself, which resulted in cases against the United States and Canada. You had other cases against developed countries, sparking a backlash domestically. You had increased utilization of ISDS. The number of cases has increased dramatically over the years, really starting around 20, 25 years ago. You had new and innovative ways of using ISDS to challenge not only direct expropriations, cancellations of concessions and the like, but regulatory issues dealing with indirect expropriation, fair and equitable, and so forth. And then you had the general sort of anti-trade sentiment that has sort of swallowed this whole area of international economic relations. You had a series of cases that were very high profile. You had the Methanex case and the Lowen case going back to ancient history. More recently, you had the Vattenfall case. You had cases against Spain in the solar sector, a number of cases against developing countries implicating environmental and other issues. And what you have today really is a coalition of the left and the right that both have serious concerns about the system. On the right, you have criticisms such as that levied by former USTR Lighthizer, who believes that ISDS eliminates what he calls the U.S. comparative advantage in legal stability. So if you create legal stability abroad, you basically encourage outbound investment and the export of jobs from the United States. You have criticisms from the left dealing with concerns about the right to regulate environmental issues and the like. The result has been the termination of a number of these bilateral investment treaties. You've had approximately 570 terminations, most of which occurred in the last several years. And all of this has sort of spurred the cottage industry of reform initiatives. So I'll put them in generally 4 baskets. So the first is reform of the substantive obligations, clarifying, narrowing, specifying in greater detail certain obligations related to things like fair and equitable treatment. You've seen this in the CETA, the Canada-EU agreement. You've seen substantive obligations or provisions related to the right to regulate, sort of basket 1. Basket 2, you've seen sort of procedural band-aids that have been proposed, whether that be the appellate mechanism or new rules on transparency, or the work that's going on in Working Group 3 related to process. These really are, in my view, sort of proxy fights or skirmishes. In some cases, they do deal with legitimate criticisms against the ISDS system, but really, this is a debate between those who dislike the system and want to abolish it, and those who are trying to save it, and they're trying to save it with process. It's sort of a classic government response. We meet a substantive criticism with process and say we formed a commission and now this is done. I would add to that sort of 2 more categories, one of which I think is particularly concerning. The first of those is the arbitrator sort of self-help mechanism, where you've seen a number of high-profile arbitrators criticize the system, which is fine, but then they go one step further and they say we need to take matters into our own hands and decide cases in ways that go beyond the 4 corners of the treaty in order to quote-unquote save the system, which is not actually the arbitrator's job, of course. The job of saving the system, if the system needs saving, is in my view, the role of governments, not arbitrators. And then you have the 4th category, which is embedded in the very long title today, which is this contract-based mechanism, which in one sense is kind of waving the white flag on future investment treaties. It's basically a sense of, well, we may not have new bilateral investment treaties, we need something else. And we'll go with a contract solution and try to come up with a mechanism where private investors can negotiate some of these protections with governments. Now, and I'll focus the remainder of my time on that issue. So the question, can a contract-based system replace bilateral investment treaties and investment chapters and free trade agreements? Sort of obviously, the answer to that is no, right? And which is not necessarily, I don't necessarily mean that as a criticism, but the direct answer to the question is no. And I'll give you sort of 2 main reasons for that. One is, at best, it only protects parties who are parties to government contracts. There are many, many cases that have been brought under investment treaties that have nothing to do with government contracts. This may or may not be an appropriate proxy measurement of how many cases might be. But, if you look at umbrella clause claims, it's only been about 16% of total cases have involved cases involving, contractual relationships. Interestingly, about half of those again are against sub-Saharan African countries. And I want to come back to that at the end. But I'll focus on three sort of specific comments on the contractual proposal. One, there's really nothing new here procedurally. You've always been able to negotiate dispute settlement mechanisms, or at least in theory you could, in contractual arrangements. So there's nothing particularly innovative about the idea of having dispute settlement. The two innovations that I think are where most of the interesting activity is are, one, the substantive obligations. Are you truly trying to replicate the substantive obligations in a bilateral investment treaty in a contract? In the sense you can't, right? So general discrimination provisions or denial of justice or pre-establishment protections, which you have in at least U.S. and sort of Canadian free trade agreements. Those are not things that you can really embed in a contractual provision. There's been some talk about turning contractualizing FET into a stabilization clause. Maybe, but I think that's probably incomplete. It doesn't capture the full scope of FET. And then the third point I'd make on this is this is an opportunity by many who are particularly critics of the system to say we should take this opportunity to layer on new obligations on investors. So not only should we replicate or not or pare back the substantive obligations and treaties, but we should layer on into these contractual agreements investor obligations, which may or may not be a good idea, but if you push that too far, then it would be another way why the system would be not utilized or investors would turn away from it. I'm slightly over time, so I guess three short questions. Is it better than nothing? Yes. Is it a replacement? No. Will it tamp down the political discontent? Maybe, but if the intent is simply to replicate what is in the current bilateral investment treaty system, which I have skepticism about, as you've seen, I do wonder what the point is, other than sort of paring back the number of cases and the number of potential claims. So I'll leave it there. Thank you.
There you have it. Clear answers to the question. Thank you, Jim. Let me put it to the panel, though. I think, in a sense, these are, as I said at the beginning, different types of legal instruments. So there's not going to be a perfect replacement. But how can investment contracts, given some of the challenges that Jim laid out, step into a potential void or where voids exist? Or any other thoughts from the panelists?
So I'll start. First thing is I agree with everything Jim said. So that's key. But I think the purpose of this fourth sort of strategy to improve or modify the ISDS system is not actually to step into that void and replace treaty-based arbitration. I think it's just sort of a fake excuse to dismantle the system and use a recourse to contract claims as a way to assuage any fears that investors will lose protection. But for many of the reasons that Jim mentioned, it actually can't step into that void and in any meaningful way and replace the current ISDS system.
Uche?
Yes, just to add that it was mentioned that the contracts, of course, apply only to the parties to them, but there's also the fact that jurisprudence arising from those individual cases would ultimately lead into all the disputes and decisions.
That's helpful and probably a good segue to the next point of discussion here, which is what are some of these differences at more of a technical legal level? And Mike, I think you're going to tackle that.
Yeah, thanks, Josh. So as Josh said, my name is Michael Rodriguez, and I'll be explaining some of the differences between treaty arbitration and contract arbitration. At the most fundamental level in treaty arbitration, as we all know, the rights and the consent to arbitrate come from an international investment treaty. And so the investor's rights exist through that treaty, whereas in a contract arbitration, the rights and consent flow directly from the clauses in the contract between the contracting parties, which are often the investor or subsidiary company and the host state or state entity. And these rights are purely contractual. And so there are consequences that flow from this fundamental difference. First, in terms of applicable law, treaty arbitration primarily applies international law, specifically the substantive protections in the treaty and the general principles of law. The treaty standards like FET, protection against expropriation, form the basis of the claims. And since they are international law standards, and investment protection treaties generally apply the same standards, an investor and a host state have an excellent idea of what, in practical terms, in real life, these protections mean. In contract arbitration, typically what you're applying is the law chosen by the parties in the contract, the governing law of the contract. And that's often the domestic law of the host state, although the parties can obviously choose other law. And as a result, there isn't a standardized set of rights and obligations in contracts. Contract clauses are unique per contract, and so is the applicable law. And unless you have a governing law that is broadly used, like New York law, it can be very difficult for one contracting party or both to have a good understanding of the relevant governing framework. In terms of standing, treaty arbitration has jurisdiction that depends on whether a claimant qualifies as an investor with a protected investment as defined by the treaty. And the investor must generally be from one state party to that treaty investing in another state. This is, as Jan Paulson calls it, arbitration without privity. The treaty encompasses, by design, foreign entities and persons without them needing to have been party to the treaty. And whereas in contract arbitration, standing generally comes from being party to that contract. As a result, only contracting parties, or if the law governing the arbitral clause allows, certain non-signatories have standing to invoke the arbitration clause. And referring back to my first point, that depends solely on whether the governing law or the law governing the arbitration clause allows third parties, non-signatories, to actually take advantage of it, and if so, in what circumstances. And so it's a lot more complicated and much more limited than treaty arbitration in that respect. Third, the nature of the claims. Treaty claims typically involve sovereign acts of a state that allegedly violate the international law standards in the treaty. And these often relate to regulatory changes, administrative decisions, and other exercises of state power. And so treaty claims cover a broad range of conduct by the host state, whereas contract claims focus on commercial breaches of specific contractual obligations like payment default, performance issues, and failure to fulfill contractual commitments. They're more similar to ordinary commercial disputes for obvious reasons, and therefore contract claims are generally more limited in scope than treaty claims are. Fourth, remedies. Treaty arbitration generally focuses on compensation for treaty breaches, and often using the international law standard for full reparation. And we know what those standards are: restitution, compensation, and satisfaction. Contract arbitration typically provides contractually specified remedies or applies the law of remedies of the governing law of the contract, which can be, again, varied per jurisdiction. And finally, on one point that Jim made, transparency. Treaty arbitrations increasingly emphasize transparency given their public law nature, and more recent treaties require public access to documents and hearings. Contract arbitrations typically remain confidential, following the traditional privacy principle of commercial arbitration. The parties can agree otherwise, but contracting parties rarely do. And this last point, while not impacting the substantive rights of the contracting parties, is, in my view, nevertheless extremely important. And that is because, for the same reason this panel exists, the attack on the legitimacy of the ISDS system. Assuming that contract arbitration could replace treaty arbitration, the same attacks that have been leveled at the latter will likely be leveled at the former. and the commercial arbitration principle of confidentiality, which doesn't technically exist but de facto does exist, will be some of the basis of those attacks. And in my view, we'll have to go through this whole exercise that we're going here right now again in 30 years. Thank you.
Thanks, Michael. That interesting discussion, particularly following Jim's, leads to a question, which is, what are some of the circumstances in which investors might prefer or prioritize an investment contract protection, even when there could be investment treaty protection? I think we saw this historically. Investment contracts were the only means of such protection, and so major companies investing abroad with significant projects would prioritize investment contracts because they didn't have investment treaty protection. But is it possible that even today, investors might think that contractual protection is preferable? Have you, any of you seen that?
Yeah, I'll just make two quick comments on that. There might be circumstances where an investor might prefer that because, you know, if you have a willing government on the other side who's willing to actually engage in this kind of discussion, you can have greater specificity and clarity as to what the obligations are. I mean, the fair and equitable treatment obligation is notoriously vague, and everybody sort of sees what they want in it. If you have a stabilization clause or something like that, that could be additive and quite valuable to investors. I guess my second comment is sort of the flip of your question. You asked what investors would get out of it. I do wonder what governments are going to actually get out of it. What governments are actually, under what circumstances would a government be willing to provide bit-like protections in a contract? I think it's highly unlikely that governments like the United States, probably even in Europe, would do it. Maybe in situations where you have more equal bargaining power, if you will, in developing countries, for example, where there may be a desire to really incentivize investment. Maybe you get that. But I think if you truly want to replicate a bit-like system by contract, I'm not sure you're going to have that many takers, frankly, on the government side. Maybe on the investor side, but I think governments would be reluctant to do it.
Other thoughts?
Sure, I'll build on what Jim had to say. So the question is essentially, in what situations would investors potentially prefer a contract over a treaty? I'm not sure they're going to prefer a contract over the treaty. Investors are going to prefer to have both. You know, what investors are looking for is stability and predictability. And so I would say particularly in the case of strategic sectors involving long-term commitments, long-term investments, where you're talking about very large infrastructure projects, telecommunications, or where you're, you know, exploring and extracting natural resources. When you're talking about these sectors that have very long timelines, investors are going to be interested in having a contract with the government that provides them, as Jim said, you know, extra specificity and stability to build on top of the broader protections of the treaty regime. So a few instances of that, but I don't want to give away all the answers from my forthcoming remarks, but I think investors would always prefer to have both because they each serve their own purposes.
Thanks, Jonathan. And it is interesting to think about this from the government perspective, because there could be a situation in which a government might be able to contract for clarity on the remedy, for example, a formula. I see an audience member who's familiar with cases where this has been negotiated with governments, where there's a formula that provides the level of compensation in certain events. That leads, I think, to the next topic we're going to discuss, which is, as Jonathan previewed, what happens when there's an overlap? Can a government provide that contractual clarity when there's also investment treaty protection? What happens when there's a potential contradiction between an investment contract and an investment treaty? So on that, I'll hand it over to Jonathan.
Thank you, Josh. Thank you to Wiley for hosting us. Thank you to our intrepid in-person audience who have braved turkey leftover comas and Arctic conditions outside to be here in person. So thank you, everybody. We've already heard a couple of people refer today to the title for today's discussion. If not investor-state treaty arbitration, then what? Well, it's a question that begs a number of questions. And for starters, should we be looking for an alternative to actually replace investment treaty arbitration? The fact remains that the investment treaty regime is robust. There remain thousands of bilateral and multilateral treaties in place today. Various of these treaties have sunset provisions that provide for extended protections for years, 10, 15, 20 years after renunciation or termination of the treaty. So the world of investment treaties may continue to evolve, but it's not going to suddenly implode. We're not going to suddenly find ourselves in a world without any investment treaties. As practitioners, when we advise clients on cross-border transactions, we consider the full array of protections. And I started getting into this a minute ago. So this obviously includes treaties today, investment treaties. This also includes investment contracts. Contracts and contract-based arbitration have always been part of the field. They were there before, during, and after the proliferation of the investment treaty regime. The first Dixie case was based on contract. Holiday Inns versus Morocco, contract to build and operate hotels. So contracts are nothing new here. An alternative headline for our discussion might be something along the lines of, in addition to investor-state treaty arbitration, then what? Maybe not as catchy as the title for today, but that one managed to lure everybody in, so we have an attentive audience. Hear me out. I have a few comments on the intersection of treaty and contract regimes. First, I'm going to address how this intersection has been addressed in certain recent investment treaties. And then second, I'll talk about how they've been addressed in some recent investment treaty jurisprudence. So to start with the treaties, and on the treaty front, I'll use the term broadly. I mean investment treaties, I mean free trade agreements with investment chapters, treaties. And I like to consider the CPTPP and the USMCA. Both demonstrate, fairly recent, that states are mindful today of investment contracts when they're negotiating investment treaties. And each takes a very different approach to the relationship between treaty and contract rights. So for the CPTPP, which entered into force in 2018, 6 years ago this month, this agreement rose from the ashes of the Trans-Pacific Partnership. The TPP had been touted as the next generation free trade agreement. It was going to be the world's largest. Among other things, it extended the scope of investor-state arbitration to include not only arbitration with respect to investment chapter obligations, but also provided a mechanism for arbitration in the event of a breach of investment agreements between investors and the host state. Investment agreement was defined as a contract between the investor and the state in relation to three main sectors: natural resources, public services, and infrastructure. This mechanism for investor-state arbitration of contract disputes never took effect, because the TPP never took effect. After President Trump issued an executive order on the first day of his first term, the U.S. withdrew, and the remaining parties to the treaty were left to figure out an alternative. And the version that did go into effect, the CPTPP, suspended, I've been practicing, I don't trip over the letters too much. So the CPTPP that did go into effect suspended a number of provisions, and this included the provisions on investment agreement claims. And as a number of the contracting parties reassured their constituents at the time, by eliminating this investor agreements provision, they were narrowing the scope of the state's exposure to the possibility of investor-state arbitration. So then we look at the USMCA, which entered into force in 2020, took a different approach. Well, I mean, first, Canada withdrew completely from the investor-state dispute chapter, so that's certainly one way to narrow your investor-state dispute mechanism. But with respect to the contractual issue, the USMCA also narrowed the scope of investor-state disputes through its treatment of investment contracts. So the USMCA does this by narrowing protections for investors that don't have contracts and broadening the protections for investors that do. These are essentially the same types of contracts that were envisioned under the TPP, contracts directly between the state and the investor in relation to three main sectors under the USMCA specified as oil and gas, and then as public services like telecommunications and infrastructure. For investors that hold a covered government contract, the broader protections apply. They're both substantive and procedural. Substantively, for example, an investor that holds a contract can submit a claim for minimum standard treatment violation, for a breach of direct or indirect expropriation, for a breach of MFN or national treaty. Procedurally, an investor with a contract can proceed straight to arbitration, subject to certain timing requirements under the treaty. In contrast, an investor that doesn't hold a contract substantively can't submit a minimum standard treatment claim, can't submit an indirect expropriation claim, can't submit a claim for MFN or national treatment violation in relation to the initial acquisition or establishment of an investment. And that investor that doesn't hold a contract is procedurally required to first exhaust local remedies. They have to pursue local proceedings for at least 30 years. That would be quite a long time, at least 30 months, unless they can show that recourse to domestic remedies is obviously futile. So comparatively speaking, as to different investor groups, the USMCA puts up procedural hurdles for investors who want to pursue treaty rights if they don't hold contracts. And it limits the scope of substantive protections for investors that don't hold contracts. We'll see what fate may befall the USMCA under the Trump administration the second time around. For now, the CPTPP and USMCA present a notable contrast in that each is adjusting, pulling on the lever of contract rights in different ways to achieve the same general aim, which is to reduce the scope of state exposure to investor-state arbitration under the treaty. Let me turn quickly to jurisprudence. The intersection of treaty and contract rights has long been a focus in investment treaty cases. And in quite a number of cases, investors have successfully brought claims for a breach of treaty obligations arising from measures that impact in some way contractual rights. There's a panel, you could teach an entire course on the range of issues that arise in this type of cases. You have, just for example, whether a breach of contract rises to the level of a treaty breach, whether a treaty breach results from measures impacting contract rights, even if the contract wasn't breached, whether a state acted as a sovereign or a commercial party, and whether that's relevant, whether a treaty permits a straight-up contract claim through the mechanism of the umbrella clause, whether a contract form selection clause is relevant to treaty jurisdiction. So the list goes on, those are just a few. As an example of concrete application of some of these principles, I'll refer quickly to the very recent award in the Telefonica v. Colombia case. So Paul Hastings' partner, Jonathan Hamilton, was on the team that secured the successful outcome for that claimant. And so let me just hit on that very quickly. First, quickly on the facts, Telefonica, through a local subsidiary, had entered into a concession contract in the 90s to provide mobile phone services. The contract contained a reversion clause that said that under the concession contract, when the concession term ended, all the infrastructure would revert back to the state. In the years to follow, to encourage further investment in the sector, Colombia passed multiple laws that established this reversion obligation was limited only to radio frequencies. The frequencies reverted to the state, but the rest of the infrastructure could remain in the hands of the investor. 15 years later, as the Telefonica concession term was expiring, the Constitutional Court of Colombia ruled that pre-existing contracts did not benefit from this new regime, so that all of the infrastructure reverted to the state at the end of the concession term. And then at the end of the term, the state required the concessionaire to pay hundreds of millions of dollars in rental fees to keep using the infrastructure that they had put in place over the course of concession. Now, the treaty tribunal ruled that these measures amounted to a breach of the fair and equitable treatment violation. It concluded, among other things, that the state had acted as a sovereign and not a commercial actor, that the state couldn't ignore the reality that long-term contracts in the technology-driven sector would over time have gaps or inadequacies, that the state had implemented a more favorable legal framework to induce new investment, and that framework had stood for 15 years. And based on that framework, Telefonica had a legitimate expectation that reversion obligation under the contract would be limited to radio frequencies. And this would apply even for contracts that pre-existed the law that went into effect. And ultimately, the tribunal ruled that the state's later decision to apply the more favorable framework only to newer contracts after 15 years was sudden, unpredictable, and disproportionate, and so an FPT violation. And finally, on the jurisdictional issue, the treaty confirmed it was dealing with treaty issues. It was addressing treaty obligations as a matter of international law, and so the contractual forum selection clause did not bar the treaty tribunal's exercise of jurisdiction. So, just to quickly wrap up, in that case, as in others, you have the intersection of contractual and treaty issues, and in that case, as in others, you have an overlap where the treaty is providing a further layer of protection on top of the protections that the contract affords. Helpful for that particular investor, to be sure, but also reinforcing more broadly the importance of transparency and stability and predictability to long-term investment in strategic sectors like telecommunications. So, much like Jim, I'll turn quickly back to the question, can investment contracts replace treaties? I would submit, no, they cannot. For the time being, contracts and treaties will continue to exist and coexist, and that's not going to change anytime soon. Thanks.
Thank you, Jonathan. I'm particularly grateful for your adept use of acronyms because it would be a shame to start Washington Arbitration Week without them. From the TPP to the USMCA, a couple questions to follow up. First, with respect to the interesting provision of the USMCA that provides potentially greater treaty protection, at least procedurally, to investors who have contracts, I'd be curious to hear the panel's thoughts on the incentives that might create, and is that a good thing? It seems to create an incentive that investors would more actively pursue contracts. Is that a good thing?
I'm not sure that it incentivizes investors to actively pursue more contracts insofar as there are some investors that can't, right? That their investments are just not subject to contracts. And so if you're out of, the fields that were mentioned, then it's not that you don't have an incentive, it's that you can't actually do anything about it. And I would think that many of the fields in which investors pursue contracts with the host state, whether it's a contract or a license or something else, are fields in which you have to pursue that contract with the state. You have to get that concession agreement to build a road, to mine, to do whatever. And so far as it does, I would think that it just increases uncertainty in terms of what the state's next action is going to be in the ISDS field and in the arbitration field, and that may offset whatever incentive is there to purposely invest in that country.
Any other thoughts on
Sure, I'll throw it again. Those provisions in USMCA are extraordinarily complex and dense, bordering on indecipherable in many cases. And so I don't know that USMCA is necessarily a path forward on this. So this is just one aside. But you can certainly imagine provisions that are clearer than what you've got there. I guess just directionally, well, first of all, I agree with the comment that was just made that there are many investors who simply can't take advantage of those provisions because they aren't in the sectors that are protected. But I think what you see in USMCA is, I'm not sure the drafters necessarily thought of it this way, but is a desire to return to what ISDS was 30, 40 years ago, which is we need to deal only with big infrastructure projects. That's where we're going to focus. We're going to focus on expropriation in those areas or some other protections, yes, but we're going to deal with the big infrastructure projects, oil, gas, telecom, and so on, and sort of leave everything else out, which is more or less what it was about 40 years ago. So all these issues about sort of sensitive, highly regulated industries are now sort of carved out. And so in that sense, I think it is an interesting sort of, maybe it's a precursor or a, you know, things to come, and how it dovetails with this whole debate about, you know, contractual protection being a proxy. I mean, so to that extent, it may be an interesting indicator, but I think in practice, it's going to be relatively narrowly used, and frankly, it's going to lead to a lot of litigation in terms of how it's actually applied in practice. Thanks.
That's interesting. The other question I had, and this is coming out of the Colombia case that you mentioned, Jonathan, and I don't mean to invite a whole new panel topic here, but there is a sense that that discussion of the tribunal about whether the state's conduct was commercial or not is important, and one that implicates the existence or not of investment contracts. Do any of you have thoughts on the relationship between sovereign immunity and an investment contract? Is it neutral, or is that something that states and investors are thinking about when considering investment contracts? Clearly, I did not plant that question in advance.
I negotiated one investment contract in the last couple of years, and so I think it is something that you think about. In my case, you know, you do think about it, but from the U.S. perspective, you know, there's an arbitration exception under the FISA, right? And I would think that many countries have similar, either de jure or de facto exceptions. There's some countries that, you know, have the principle of sovereign immunity, like Panama, one of my clients, and it doesn't, it's actually not codified anywhere, it's just the jurisprudence. And I would think that when you're negotiating an investment agreement, given how many countries, or contract, given how many countries have executed the European Convention, you would assume that most countries have some sort of arbitration exception to their sovereign immunity, and that a contract will have an arbitration clause in there.
It might seem simple until you start reading some of the DC Circuit cases of the past year or two. But that's a topic for another day. So I think we've talked a lot about investment treaties and investment contracts. And I think, as this panel has explained, this is not an issue of alternatives, but it's going to be one where there's an additive or overlapping nature. But that leaves one piece of our topic that has not yet been discussed, which is the then what? If not investor-state treaty arbitration, then what? And I probably, the best person here to speak on that is a former senior counsel at ICSID who worked on the ICSID Rules Amendment. So Uche, what else should we be considering when it comes to investment disputes?
Well, thank you, Josh. Thanks to Jose Antonio as well, and to Ian and Sharon for being here, whether virtually or in person. By the way, I didn't want to weigh in on some of the questions because there's quite some overlap. Now, these questions before us, as we heard, are premised on the fact of the pushback against the investment treaty arbitration, which I've been seeing more recently. I'll be focusing on, like you mentioned, Josh, on the second prong. If not investment treaty, then what? And as we heard, investment treaty arbitration is not going away anytime soon. So a lot of what I was saying would actually be forward-looking. The response to that would be, if not investment treaty arbitration, there could be investment contract arbitration, like we've heard a lot this morning. But again, not all investors have access to that. Then there's investment law arbitration, which also exists. But then if we assume that the pushback, at least in some parts of the world, is against investor-state arbitration as a whole, then if not investor-state arbitration, then what? Now that's if arbitration is not available at all, either under treaty, contract, or investment law. Well, there are so many options. I'll mention some. One is the obvious option of going to the domestic courts. using dispute resolution boards, especially in large infrastructure projects, taking qualifying disputes to human rights courts is an option, resorting to other forms of ADR, such as mediation, and of course the age-old state-to-state cooperation and dispute settlement mechanisms. There is also political risk insurance, which could play a role, not so much as a way to resolve disputes, but as a way to obtain redress. Now, I just want to focus on two of these options, national courts and ADR. Actions before domestic courts of the host state of the investment remain an option, but there are obstacles. One is the question of possible bias that is often talked about, whether real or not, especially when you have you're taking the state to courts in its jurisdiction. There's the practical issue of representation, who have a right of audience in those courts, and it will be typically the lawyers qualified in those jurisdictions. Now, there is also the issue of the available remedies that are available under domestic law and therefore available in the court. And this includes the issue of compensation, damages, how will they be assessed if applying the domestic standards. It's actually been said that by the very nature of investment treaty arbitration, certain issues can only be resolved through the application of international law. I think it was Banifatemi that said that. Then there's the issue of enforcement. That's an enforcement of a cross-border enforcement of domestic court judgments. And that's even with the existence of the Hague Conventions of 2005 and 2019. But then it's not all doom and gloom if parties were to go to domestic courts. In fact, there are instances right now in which domestic courts could be preferred, even when international arbitration is available. And that's where there's some overlap with the talk about investment contract arbitration. Some of those apply as well. Now, these reasons could include costs, it could include even the ease of enforcing a court judgment against the state, especially where the amount in question is not significant. The question of availability of the option of appeal before domestic courts is also attractive in some instances. And there are political considerations. In certain situations, an investor may strategically choose to use domestic courts to avoid potential negative political repercussions. And this reminds me of an event that I spoke at about 20 years ago, addressing international oil company executives about the benefits of ICSID arbitration. Now, many were horrified by the idea of high-profile arbitration unfolding at the World Bank against their host governments, and what this could mean for their investments and this long term. Now, they were less hesitant about domestic actions that did not play out on the global stage. They also liked the idea of other forms of ADR that were less confrontational. But the main challenge was the idea of spending resources and time on a process that would conclude with no enforceable outcome. And so this brings me to the other option available, which is mediation. Now, with the Singapore Convention on Mediation available, we may see more use of mediation for investor-state disputes, but it's still early days. So far, the convention has been signed by 57 countries and ratified by 14. Interestingly, the jurisdictions that are yet to ratify the convention include some in which assets are located that parties typically would seek to enforce against: the US, the UK, Switzerland, France, and so on. Now, it's possible that as access to international arbitration starts to wind down, that there may be need, states may see the need to expand access to mediation by signing on to the convention. So to wrap it up, I'll say as long as states are open to foreign investments, disputes will naturally keep arising. And when they do, arbitration is the choice method of resolving them. But if that doesn't exist, there are other options. Down the road, the effect of market forces could drive countries that wish to offer incentives to investors to make available before their courts the types of remedies that are now more freely available under international law. The resulting increase in the use of domestic courts would naturally lead to the strengthening of domestic legal systems across the world, along with the appeal to disputing parties. And finally, we could see an increase in the use of mediation as more countries ratify the Singapore Convention. I'll stop here.
Thank you, Jay. I think that's a helpful demonstration of why this is not a simple question of either or with investment contracts or investment arbitration. Before I pose a question for the panel, I want to remind everyone who's attending that there will be a time for questions. So I hope that you're considering those, and we will turn to those at the end of our time. But before we do that, I want to ask the panel, any thoughts on these examples that Uche laid out? Do they give you more hope, domestic courts, other forms of ADR, in this discussion of, if not investor treaty arbitration, then what?
Yeah, I'll make two comments, one on mediation, one on domestic courts. So the mediation option, in theory, is appealing. I am deeply skeptical that it will actually be workable in practice. I mean, if you've seen the way states tend to react to these kinds of claims as if the investor has levied an insult to the people of the nation, and they get outraged and how dare they do this. And they very quickly box themselves into a place where a negotiated solution or even a mediated solution is not practical. Like it may work for more routine cases, if there are routine cases these days. I think for the highly politicized cases or the controversial cases, the high-profile cases, it's going to be very difficult, I think, for a state to enter into a mediated solution where they will sort of voluntarily agree to compensate or do something else. On domestic courts, maybe the whole reason we had investor-state arbitration is to sort of depoliticize disputes, according to whether that actually worked in practice. But depoliticize disputes, take disputes out of the context of domestic court and internationalize them. Obviously, this is a different model. That may be, though, where we're headed on some of these things. I mean, there have certainly been instances where countries have tried to codify in domestic law bit-like protections. They've also sort of offered arbitration in that context, but maybe they'll allow that in the context of domestic litigation, and maybe for a time that's going to be the outcome. Is you'll have these substantive obligations or something that looks like it, but you have to litigate it domestically. Maybe that will take the air out of the balloon related to the controversial nature of ISDS and these sort of nameless international tribunals. So it's possible. Again, it's not a replacement, but I can see that as a potential way forward. But on mediation, I think that's going to be very difficult to implement and operationalize in an effective way. Thanks.
Other thoughts on that?
Sure, I'll offer thoughts again as to mediation and local dispute resolution. First, with respect to the possibility of a negotiated solution, I would remain skeptical of that as well. And I would note, one of the advantages of the investment treaty arbitration framework is that these treaties provide for typically provide for notice and some consultation period. So the treaties afford the opportunity for a negotiated resolution. And with the backing of a treaty claim to follow if there's no negotiated resolution to be found. And I think that offers a bit more bite than just a straight up mediation negotiation context that doesn't have, the teeth of a potential claim on the horizon to really crystallize the issues and perhaps bring the parties closer to a negotiated resolution. Likewise, with respect to local courts, not all doom and gloom. I understand, but I also go back to, what are some of the fundamental tenets of treaty arbitration or just international arbitration generally. And it's that, you're providing a neutral forum for resolution of dispute that takes you out of the place where the problem arose and, the laws under which the problem arose. And I'm sure that various investors would be skeptical, especially those that are dealing with adverse action by local courts, that they are going to receive full and fair hearing of their issues and proper resolution of the problem if their only option is to resort to the very local system that they're struggling with issues in relation to their investment.
Follow up to that, again, just to remind that these options arise in that world where investment treaty arbitration is not available or have an investment contract. So what do? Now, negotiated settlements, I totally agree with what you both said. If you look at the exit records today, the last 10 cases that were concluded were, I think, probably 8 or 9 of them were settled cases. So it's not totally unheard of, especially contract cases. For some reason they tend to have a higher percentage of settlement. So again, this is all happening while arbitration is still possible under treaties and laws and contracts. But in that world where it's not at all possible, the question is, what next? If we don't go to the courts, if we don't try mediation, what do we do?
I'm just going to throw out a couple of thoughts here, building off what my co-panelists have said. In terms of negotiated settlements, that's already done, even before you get a notice of dispute, and you have the cooling off period and the amicable settlement period. I can't think of many cases in which an investor has a large investment in a foreign country and they're subject to some regulatory change or judicial decision or anything. And from the moment that happens, or even before, when they see that there's a potential for this happening, they're not already engaging with the state. And so there might be more pressure to reach a negotiated settlement because the investor will have to bear more risk if there's no treaty arbitration or contract arbitration. But negotiated resolutions, or at least the attempt of that, already happens. In terms of domestic courts, in moderate to big cases, in cases that have some amount of national importance, publicity, if you think that domestic courts can be impartial and not political, I would highly disagree with you. And then on other international mechanisms, going back to what was just said, if the question is an attack on ISDS as a whole and not just arbitration or that arbitration aspect, then every mechanism that will replace it, call it mediation, conciliation, whatever it is, other than national courts, unless those courts rule for the investor, will be subject to the same criticisms that arbitration is subject to now. Because 90% of the people who disagree with treaty-based arbitration can't pronounce the phrase distinct legal instruments. And the 10% that can don't actually care. They care about the states having more ambit to act and more scope to act and to have their risk of an adverse award or mediation contract, conciliation agreement reduced. It's not really about what the mechanism or what the international instrument is. It's actually about increasing protection for the states.
I'll follow up to that. Again, the where we are now, we're still at the pushback phase. What's going to come down the road is where states, having gotten to where they are, certain states may feel the need to again throw out incentives to investors. And the question becomes, what is it that they can throw out which would make sense to the investors? Because by this time they've painted themselves into a corner where arbitration is not available. And this is where I think there might actually be some traction with the Singapore Convention if the state is able to signal that at least this is available. That could be useful.
Let me open it up now with thanks again to the panel for these interesting remarks. We would love to hear your questions. We've covered, I think, almost every potential topic in investment arbitration when it comes to claims and alternatives. So anything is fair game. Questions?
Sure. Jim, I was struck that you said investors may be willing in a contract to incorporate the bid protections and sovereigns would not, right? Does that suggest there's an imbalance in the design of the bits to begin with that could be remedied? Why is it that sovereign would enter the treaty but then not offer those protections unless they don't value them the same way anymore?
And I'll repeat the question for the benefit of our online
You can make it
members. Well, I think Jim heard the question and can address it. It was to him specifically, and it was really a question of what is in the investment treaty, what is in the bid, and the states and the investors having different approaches to that. But I think those incentives will come out in your answer.
Yeah, I mean, just to give you an example, and then I'll answer your question. So, the United States has entered into not that many bids compared to many others, but I don't know, 40 some odd bids, running treaties with ISDS and not sure they will ever do it again, but they have, at least in the foreseeable future, they have done. But arbitration of government contracts is exceedingly rare in the U.S. That's just an example of the dynamic. It doesn't really answer your question. Why is that? So I think there are two different contexts and two different dynamics at play. So if you're talking about a bid is kind of a signal. One, it's out of the context of any particular dispute or any particular contractual relationship. It's a signal to the world, come invest here because we've got, at least this is the theory, we've got a mechanism, we've got a floor level of protection, we've got a dispute settlement, and come here and you can invest sort of safely. Like that's the idea. The dynamic is somewhat different when you're in a one-on-one negotiation and contractual relationship in a government contract, right? You've got a ready investor who's ready to come in, and you're just negotiating terms. It's just a very different political dynamic, and I am skeptical. Which isn't to detract from your question. I mean, maybe it does imply an imbalance, but I think the political context is different. I am very skeptical that governments are going to be willing to negotiate these kinds of terms in investment contracts. And just one.
Jim, if I can just, the issue isn't whether they negotiate them in contracts. I was just using that to raise the issue of, is there modification to bids that might make it so that it's easier to imagine? Not that you would do it.
Is there a modification of bids as opposed to an alternative to a bid? Yeah. Look, I mean, I am actually, I actually think that there is room for improvement in bids, right? I mean, these protections are sort of notoriously vague in a lot of ways. I appreciate the effort that has been made in CETA, for example, to provide greater specificity to fair and equitable treatment. You can agree or disagree on the particular elements that they put in place there. But I do think there is room for greater explication of the rules in bilateral investment treaties to remove some of the uncertainty and vagueness that bothers people, if that's the question. How you do that with respect to the hundreds of bits that are already out there, different question. You can imagine ways it's a different discussion. You can imagine ways how to do that. But yeah, I think I think that the issue we have is politically, the idea of BITs and investment chapters in free trade agreements has become sort of politically toxic. Like there's nobody who's willing to fight for that right now. And so people are withdrawing or opting out of the process or just not negotiating new treaties or what have you. And I think the contract-based solution is an alternative to say we're not doing a bid, we're doing something else, and pretend like we're getting the same level of protection. I mean, I think that's the sort of dynamic at play. But anyway, so I'm still not sure I answered your question directly, but I do think there's room for improvement in bids. I'm not sure there's a political appetite to negotiate any new bids that would allow that improvement to be put in place.
I see another question over here.
So my question is, I don't know how often we've seen this, but from my jurisdiction, which is Nigeria, what we've tried to do, and Mr. Guichard will probably correct me, he's a more experienced lawyer than I am. But what we've tried to do was to create a system whereby, by way of domestic law, national legislation, we have an investment promotion commission act that gives a procedural approach to this issue. It tells you when there's a dispute, irrespective of greenfield or brownfield investments. So even in M&A transactions, you always say this. If there's a dispute between the parties, your recourse would be to go by way of mutual discussions and resolve it. Now, while that is going on, you have the options of if you're a domestic investor, you could go under arbitration by way of the National Arbitration Act. We made a new law recently creating the Arbitration and Mediation Act of Nigeria just last year. If you're a foreign investor, you could go under an international commercial investment, or you could go by way of any agreement, maybe any institution agreed under your investment contract. Now, if you are either foreign or domestic, you can agree to any multilateral, bilateral treaty. In this case, the Singapore Convention can come into play, by which you can resolve your dispute. So you could go either by way of mediation or arbitration, maybe UNCITRAL or any other arbitration, maybe ICC to resolve a dispute. Now, if you're a government entity and there's a bilateral treaty in place or a free trade agreement in place, you have the final option of going pursuant to ICSID to resolve the dispute. So what we've seen by what the law seems to do was like every investor is protected. First and foremost, resolve your matter by way of mutually discussing, resolving issues. And if you fail to do that, you now have these options all outlined for you, and then you can pigeonhole your dispute or your claim to a particular option in trying to resolve it. So the question now is, I think that's pretty much one of the most standard model that anybody could see because it was recently passed into law. I don't know how often other jurisdictions have tried to mirror this or try to have a multi-tie level to dispute resolution, in terms of resolving things, and then having a composite approach that captures virtually everything we're talking about now.
Thanks for that question. Again, in case the online members couldn't hear, the question and focusing on the example of Nigeria is multi-tier protection for investors. How does that fit in? Is that a promising avenue here? I'll open that to the panel. Maybe while you're thinking about it, one thing I would note is that a point that came out early on in this discussion was the signaling. That really was the promise of investment treaties early on, to signal to investors internationally that we as a government will uphold the rule of law, we will welcome your investments, we'll protect your investments in order to encourage flows of capital. And to what extent can a multi-tier system, particularly one that might lack or put limits on investment arbitration, compensate for that signaling deficit?
Well, I guess it falls on me. Again, it's all about the messaging, as you said. This is taking it one step further. If we're saying that investment treaty arbitration is not readily available, then there are signals to foreign investors, and that's what I was getting at earlier. This is a good example of it. And one point about the courts that I forgot to mention earlier, the recent cases involving these ECT cases involving Spain, Italy, Czech Republic, and so on. there's some aspects of it playing out in domestic courts while they're in arbitration. So it's not exactly a lost cause.
Any final remarks? I see that we're at the end of our time, so I see nothing pressing coming from our panel, so I do see one last. Antonio?
Thank you, Josh, and thank you to all the speakers for a wonderful panel. I want to ask something from a more skeptical perspective. I mean, isn't and and I fully agree with the title. We worked at it, but upon reflection, isn't this whole discussion about investment, contract arbitration more of a sort of marketing, opportunistic packaging exercise, and I'm thinking more in terms of, well, the first time that I perhaps may have heard the notion of, oh, we're going to replace investment treaties by investment contracts, might have been perhaps from the perspective of the ICC, and then other centers looked into it. I mean, I'm not sure if ICC is looking into it as much as other arbitration centers. And then, well, we're going to do this because there is so much weight and disenchantment on the investment treaty arbitration that we're going to replace it. And you have very well proven that one thing is contract and another thing is treaty, so they're not really interchangeable. So I'm more thinking in terms of, are we simply seeing an opportunistic change so that to the extent that they can, other centers, more commercial based, gain a marketplace for their ultimate clauses. And I hate to be the skeptical one, but there is a push, a marketing push by the center. So I wonder, what do you think?
What a cynical comment. But no, yes, I'm sure that that's true. Actually, I'm sure that that there are certain arbitration centers that see this as an opportunity for them to get in the game on this. But that said, I don't know that means we shouldn't have a debate about it, right? I mean, there there's clearly a problem, right? There's a problem and there's no obvious solution. The problem being this sort of political backlash against ISDS, and what do? We need to fix it. And the effective dissolution of the ECT, withdrawals and terminations of bids. I mean, the politics are just not great. And if if we are interested in investment protection, we need a solution. I actually, whether it was a cynical marketing ploy or not a cynical marketing ploy, I think it's worth having the discussion and seeing if there's something there, because if the bids aren't going to go away, there's still hundreds of them out there. So whether they're new ones or not is a different question. But they're still there. But if you want a path forward to fill the gaps or something, you need something. And maybe this is an opportunity. It's not, as I said in the beginning, I don't think it's a replacement. But it could be useful nonetheless.
So perhaps rather than a cynical marketing ploy, it's a benevolent marketing ploy. Because I think, and I know that our time is up to wrap this up, I think the consensus here is that it's not a question of either or investment contracts or investment treaties, certainly not for the foreseeable future. It might be a question of both and how do we then live in a world in which both types of protection can exist for investors. To wrap up, I want to thank our organizers again, Ian and Jose Antonio from Washington Arbitration Week. Thank you to the audience for starting off this week with such a great discussion, and thanks for the panel members for their excellent insights and valuable contributions.